All right. Thank you for joining us today, everybody. Welcome back to another episode on the Forbes Podcast, where we have conversations to inspire, empower, and educate. And today I'm honored to have on the podcast, we have Cheryl Cruickshanks, who is a lawyer and was called to the bar in 2009. And she's been practicing in real estate and estate law for over 15 years. She also owns her own law practice in Bolton. So Cheryl, thank you so much for joining us today.
Thank you for having me, Penny.
To start off, I'd love to hear what led you into law and what inspired you to eventually open your own law practice.
So I was interested in law from a relatively young age. I wanted to have a career that would be fulfilling and something that I feel like I could have a good, work-life balance with as well. So I was never interested in the Bay Street firms. I always knew I kind of wanted to be in more of a small or local firm as opposed to being in Toronto. And I love to read, and I always made the time to read when I was younger. So that's how I initially came down this path. I ended up going through the Yellow Pages when I was in university, and a sole practitioner in Brampton hired me, and I worked there as a summer student for most of the summers, all the way up to the end of my law school studies. I did a lot of administrative work, helped the clerks, and he did mostly residential real estate. And so that's how I started in that particular field of law. He did wills and estates as well, but that wasn't something that I got involved in at that point. And then when I was in search of an articling position after finishing law school, I ended up articling with a sole practitioner in Bolton. And he was a general practitioner, so I was able to experience many different areas of law, including real estate and wills and estates. And those were the areas I just kind of gravitated towards. I find, it's pretty fulfilling. Clients generally tend to be relatively happy, of course, aside from estates when someone has passed. Yeah. But as opposed to a more litigative kind of nature, I prefer what they call the solicitor work. And my articling principal then ended up contacting me a number of years after I became a lawyer, asked me if I wanted to come back and start my own practice because he wanted to phase out and retire. And so I took over his real estate practice as a sole practitioner, sharing office space with him and other lawyers in the same space. And that's where I am today.
That's amazing.
Yeah. So it's great because there are other other lawyers who can bounce ideas off of. We have different practice areas. And so it's a great opportunity for referral and networking.
That's amazing. And it's always, I find it helpful too, to have colleagues, right? Like it's great to have that camaraderie. And as you said, the different ideas and people to bounce things off of. That's great.
Correct.
Now, for those listening who may be on a similar path, do you have any advice for someone considering a legal career or thinking about launching their own practice?
So in terms of launching your own practice, I would say take the leap. There's always a risk, and all entrepreneurs made that initial leap and risk in order to get where they are. And try to be in a location where you're more likely to receive referrals from other lawyers, such as a shared office space environment like I'm in, where they practice different areas and you can have that cross referrals of clients, or just in an area or community where there is a need for your area of practice. Some smaller towns or communities don't have many lawyers, or they may have certain areas that aren't covered by lawyers that are currently practicing there. So try to think outside of the box and outside of your comfort zone, including your desired location. And I do find word of mouth tends to spread faster in smaller towns. So if you establish a good reputation, then a lot of people, both residents and other professionals, will get to know you very quickly, and you'll find work tends to come in that way. And also, don't be afraid to ask for help and consult with other lawyers. I've been practicing for just over 15 years, and I still have questions that come up, things that I've never addressed before or encountered before, or just things that I need that secondary opinion on. And then in terms of a legal career, I would say try to get experience by volunteering or working in law firms before you even start law school, or even before university, to get an idea of the environment and whether it might be a good fit for you. And it helps also in determining what area of law you might be most interested in practicing. So you can try to take certain courses in school that will help you focus that. And don't turn your nose up at administrative tasks. You have to kind of get your feet wet and know the ins and outs of the practice from the bottom up.
Great guidance. That's great. From your experience, what are some things that buyers and sellers often don't realize about the legal side of a real estate transaction?
So I find a number of people tend to view real estate lawyers in particular as an unnecessary part, just a required formality. And however, it's much more than just pushing papers and carrying out the formalities of closing a transaction. In the context of a sale, a straightforward transaction is becoming less and less common. I've experienced many instances where buyers seeking an extension of the closing date from my client who's selling, and therefore I have to ensure to the best of my ability that the terms of the extension are carefully constructed to place my client in the same or better financial position they would have been in had it closed. And with respect to purchases, I conduct a title search and review it in detail to ensure my purchaser clients know what is on title, how it may affect them, and also to ensure there are no title or access issues with the property.
That's great. What are some common, and you may kind of answer these, but some common legal hiccups or red flags you see in real estate transactions that buyers and sellers should keep aware of? Things such as maybe title issues, easements, status certificates, pre-construction issues.
So title issues, there's the obvious like mortgages to be discharged, but then there's more complicated things, which I touched upon, that there may be issues with access to the property, either on foot or by vehicle. So we want to make sure that there is legal registered access. And this tends to come up especially with cottage properties. Many are still only accessible by private road or don't have legal registered access. And so I'm there to determine what the situation is, advise my client accordingly, and see if it can be resolved by carrying forward an easement that may have been granted in the past, but lost when the property was brought forward from the old paper system to the electronic system. Easements, that ties into that as well, can include like the standard ones you see in subdivisions where the municipality has an easement to allow for water drainage to go across the property. You're not allowed to put anything that would obstruct that or change the grading that's been set by them. It can also include a right for a neighboring landowner to walk or drive across your property to access theirs, or for a neighbor to step on to make repairs to their house in situations where it's very close to the lot line that you share with them. And so these are just some of the things we look out for when conducting title searches so that our clients who are buying are aware of them. With status certificates, it's important to compare the legal description on the agreement with what's set out in the status certificate to confirm they match and to confirm what units, such as parking and locker units, are owned versus which are just what they call exclusive use and form part of the condominium corporation. Status certificates typically reiterate that it's the buyer's responsibility to check the units they are purchasing to make sure that any changes that an existing or previous owner made obtained the requisite consent from the condominium corporation if it was required. And of course, it's quite difficult to actually do this in practice. So I always recommend that certain clauses be included in the agreement of purchase and sale, if not already there, which then allows for the seller to provide a warranty at least, confirming that no changes have been made unless consent was received, and that at least gives the buyer a way to go after the seller if it turns out to be untrue. And then pre-construction, I just find that, there's many clauses that buyers just need to review and be aware of, because when we're doing it as lawyers and reviewing a new build agreement, we can't point everything out, right? So I always ask clients to read through it themselves as best as they can. And for condominium purchases, there is the ability to pay an extra amount to save on the interest that will form part of their monthly occupancy fee. But you need to give that to the builder or let them know you want to do that within the first 10 days. Otherwise, they might charge a fee or might refuse to allow you to. And so I always point that out to my clients as well.
Very insightful, Cheryl. This is all, again, I think when you're a buyer or a seller, because you don't do these things all the time, they don't really realize how much is actually involved. So you play a fundamental role in making sure that legally things are, as you said, in their favor and structured right. So that's excellent. Now, let's clarify something. I mean, I always get asked about, again, from my prior role too, and just my knowledge of it. And I'm sure you do too. And when you're drafting things, to understand the difference between what is a joint tenant versus a tenant in common and why it matters.
So a joint tenant involves two or more persons who hold equal ownership interests without specifying their shares. Together, they have a combined 100% interest, and it's treated as indivisible unless there's a reason to divide them, which I will touch upon afterwards about severing joint tenancy. So it entitles each of the owners to a right of survivorship. So if one of the owners were to pass away, the surviving owners is automatically entitled to take full ownership of the property, essentially assume the deceased owner's share, and then whoever's left still holds equal ownership between them. It does not pass through the deceased owner's will or estate, which is an important thing to note. So if someone is counting on a property going in pursuant with their will, they have to keep in mind if it's a joint tenancy, that will not happen. It will automatically go to the surviving owner. However, there are certain ways that a joint tenancy might be severed, either intentionally or unintentionally. So one of the joint tenants can register a deed to themselves, stipulating that it is to sever the joint tenancy. They can do this without the knowledge or consent of the other owners. And this is usually done in the context of a family law separation. Maybe one of the spouses wants to make sure their separate interest is protected and not doesn't defer to their separated spouse if they pass away in the meantime. And then the other situation might be where an individual holds title as joint tenants with someone who is not their spouse. If that's a matrimonial home and that person who is on title passes, then the joint tenancy is deemed to be severed to protect the spouse who is not on title. Because it is a matrimonial property, we want to make sure that their interest in the property and their right to occupy the property is protected until it's sorted out. And then another way is what we call through the doctrine of resulting trust. So a parent might want to add their adult child on title thinking they're getting older. I want to put them on title as a joint tenant to avoid probate. The problem with that is, in addition to all the risks with taxes and creditor claims and whatnot, the joint tenancy might be deemed to be severed upon the death of the parent, because if there's anyone to challenge the estate or the will, other beneficiaries may see that as what they call a resulting trust. And that is a presumption at law where the idea is the child was just holding title in trust for the parent, and it would still fall under the estate. With tenants in common, that's where you have specified separate ownership interests, so it could either be 50-50 or otherwise. And unlike joint tenancy, the separate ownership interests do pass through the estate when each person dies. So either by will or under intestacy.
Okay, so sorry, I don't know if you want to add anything else there.
Well, with tenants in common, joint tenancy, I was going to say, tends to be done between spouses who are married. That is very common, unless maybe they have children from a previous relationship who they want to benefit from the property. It makes it easy for things to just pass between spouses without having to go through the cost and the time involved with probate if one dies. Tenancy in common is beneficial for anyone, who's not married, maybe between siblings, other relationships. Even some situations with spouses, if one of them has their own business, some may do a tenancy in common situation. But that being said, if anyone wants to do that, they should talk to a family law lawyer to make sure they're not then hindering their ability to claim in the event of relationship breakdown under the Family Law Act.
Right. It's so complicated, right? As you can hear from Cheryl, from you speaking, and even me having knowledge in it, I think it really is important for people to understand, if they're married, if they're single, if they're going through a marital breakdown, it's really important to, as you said, seek legal advice to make sure that you're doing everything to protect yourself and really understand the legal ownership that you have.
Correct. Because
I don't think a lot of people even really look into it or know that it's something that's so important. And as you said, joint tenants, that right of survivorship, a benefit of it too for spouses is that you avoid that probate fee, which
Right.
is a 1.5% tax on the estate if you were to pass away. So that's another benefit, but it's got to look at, again, the legalities. As you said, if you have a will, it doesn't necessarily mean that that's going to be reflected if it's bypassing the will, what your
Correct.
wishes are.
Correct. And some people also don't realize, even under joint tenancy, the value of the property could still be pulled into the calculation of the probate fee or tax if you have other assets that are subject to probate. So it's important to have a lawyer look at your entire portfolio and work out an estate plan so you know what will happen when you do pass.
Absolutely. That's great. Great guidance. Okay, switching gears a bit, which we've sort of talked about, into estate law. Can you share why having a will and power of attorney in place is so important?
So if a person dies in Ontario without a valid will, the law then dictates who inherits their estate and in what amounts or proportions, which is known as the law of intestacy or intestate succession. So under the law of intestacy, if the deceased had a spouse to whom they were married and not separated at the time of death, and this is as defined under the Ontario Succession Law Reform Act, the spouse is entitled to a preferential share, which is currently set at $350,000. So the first $350,000 of the deceased estate that is available under their estate, by their will, not including other property that would not fall under that, goes to the spouse, or the spouse is entitled to claim that at least if they choose. And then the remainder gets divided equally between the spouse and any children of the deceased. So this can pose an issue, particularly in situations where the deceased did have children from previous relationship who they want to inherit in equal amounts, or possibly more than the spouse, or if they don't want the spouse to inherit, this can of course cause complex issues and litigation, whatnot, and it doesn't set out what their wishes are. So this reiterates the importance of having a valid will in this context to make sure that your wishes are well known and it is in a valid, legal, and binding document. And another concern about passing away without a will is that your wishes about who will take care of administering your estate are not set out. So in that case, anyone can apply to the court to be appointed as the executor or estate trustee, which terms are generally used interchangeably. That being said, even if you have a valid will, it can be challenged by others, and another individual could apply to the court to be appointed. So it's not foolproof to have a will, but it sets things up for success more so than just leaving it to what the law dictates. For powers of attorney, unlike wills, they're only in effect when a person is alive. The person who signs a power of attorney is known as a grantor. And I find many clients don't realize the importance of having it in addition to a will. The best way to think about it is that it allows for someone else whom you trust to manage your assets and pay your debts while you're still alive. And this is important because it ensures your assets are best maintained for your estate beneficiaries once you die. Without that in place, things might be not taken care of properly, and then the estate that you intended to have as set out in your will is not there. So powers of attorney address what's to happen with your property and personal care while you're not capable of making the decisions yourself. That being said, a power of attorney for property usually is set up to come into effect right away to avoid the need to wait for a capacity assessment to be done when you do have debts that need to be paid. For personal care, it's only when the grantor is incapable of making decisions for themselves, which can be either as a result of mental incapacity or physical, such as being unconscious or in a coma. Without a power of attorney for property, your loved ones must apply to become your guardian for property, which can be a lengthy and more costly process. And it delays their ability to sell your house, for example, if you need to sell it in order to cover the costs to move into a retirement home, and also allows them to deal with your bank accounts and other assets, but that is then again delayed by that process. With personal care, medical professionals would instead rely on the hierarchy of substitute decision makers under the Healthcare Consent Act, but that may or may not coincide with your wishes. So again, it's important to have those binding legal documents that set out exactly what you want to happen.
It's so insightful, right? And so important, I think, for people to know. And I guess I don't think people realize, maybe because they're too busy or we don't want to confront the fears of being sick or passing away. But I think the will is, as you said, so important from looking at, where do you want your money to go? If you were not here, how do you want things to happen or unfold? Because people don't realize it might not necessarily go the way they want it to, or even to the spouse for that matter, depending on the way things are structured. And then also, I think another important thing too is for guardianship for children, right? For parents who have children, knowing if both of you were to pass away, which is unlikely, but in the tragic event that you both weren't there, who do you want that person to be to take care of your children? Someone would, I believe, correct me if I'm wrong, Cheryl, but have to apply to the court to obtain guardianship, and that might be not the person that you wanted.
Correct. Well, and a guardianship appointment for children in a will, it is only valid for the first 90 days. So I do always let clients know as well. The guardian will still need to apply to the court, but the will is, good evidence as to the parent's wishes. So the court will definitely look at that in considering the guardianship application. Yeah.
Excellent insight there, Cheryl. Now, in terms of business owners, when might a secondary will be necessary, or do you find it advantageous, and what advantages does it provide, a secondary will?
So secondary will, first off, is typically for the purpose of separating assets from other assets that are subject to probate. So meaning subject to the estate administration tax and going through the process of obtaining a probate certificate from the court. So those other assets might include shares owned in a private corporation. A secondary will would allow those shares to be transferred more efficiently without the need to wait for the court to issue a probate certificate in order to transfer them, and without the need to pay the estate administration tax on the value of those shares. If there is no secondary will, then all assets that flow through the estate of the deceased will be subject to probate, even though they could have been exempt if only they had been dealt with in a secondary will. Secondary will also allows for privacy when dealing with privately owned businesses, in addition to the cost and time savings previously mentioned. A secondary will, in addition to that, would allow you to appoint someone else to administer certain assets of your estate, as opposed to the person who is appointed under what we call your primary will to deal with your personal assets. So this is important for the management of business assets, for example, as it may require certain knowledge or qualifications depending what field you're in. And one kind of concrete example of that is in my practice, as a lawyer, and I have a professional corporation. We don't have to have a separate will for our professional corporation, but it's important to have that, and also to have that succession plan in place, where we have someone who is going to have the knowledge to carry it out. And generally, we would prefer to appoint a lawyer to do so, so they could also finish up whatever files need to be dealt with if we die, unexpectedly, right? We still have ongoing matters that need to be addressed. That person can step in, finish up those files, and either tie up the practice, wind it down, or just take it over.
Great takeaways there, and important points you've made, Cheryl. Now, on a personal side, is there a book or a podcast or a mentor that has had a profound impact on you?
Not in particular, but I have had quite a few lawyers I've worked with over the years who I would see as mentors, who I am so thankful to have had, and I really value their opinion and their advice. I could still go to them even now if I have questions that come up that I'm not sure about. I just want to bounce it off of them, or something I haven't dealt with. They have many more years of experience in practice. And so I've looked up to them, not just from an advice perspective, but also a practice perspective, kind of mirroring or modeling how to run my practice off of them, and aspiring to have that type of practice, especially where you have more of a familial type of environment as opposed to a really competitive environment. I find it's nice to have that smaller firm feel, where everyone kind of works together and you feel like you're part of a second family, so to speak.
So true. That's amazing. Now, to wrap up, is there one takeaway that you'd like the listener to leave with, or one important thing that you think that they could take away, what would that be?
So I would say there's no substitute for sound legal advice, especially when dealing with such a large transaction, such as purchasing or selling real estate, and when dealing with your overall property and personal well-being. So it is advisable to seek and pay for proper legal advice. It's a sound investment. It's a very low cost in comparison to the amount at stake. And in comparison to the alternative of not having things properly handled and in order, whether it's to do with your house, your estate, or just your overall health and well-being, and what's going to happen when you can't do anything on your own.
So true. Such a peace of mind. That's great. Well, Cheryl, thank you so much for being on the podcast, for providing your guidance and insights. We really, really appreciate it. To our listeners, if there's anyone in your network or your family or friends who you think could benefit from this episode, please share it with them. And I'm going to link in the show notes, Cheryl, all of your contact information. So thank you so much for joining us. We really appreciate it.
Thank you.
Okay. Have a great day.
You too. Thanks. Bye-bye.